Just moments ago, another juror in the trial of the theater shooting suspect James Holmes, he was dismissed. This is the fifth juror to be dismissed from this murder trial. Meanwhile, a psychiatrist for Holmes testified that he thought about killing people 3 to 4 times a day before he went on that deadly rampage. Remember, he did kill 12 people that day and injure many more. Yet Dr. Lynn Fenton told the jury that she couldn't place Holmes under a psychiatric hold because he never disclosed a specific plot or a target in their conversations.
Fenton testified that Holmes' obsession with killing was only getting worse as his treatment progressed. And just hours before the attack, Holmes mailed Fenton a notebook with elaborate sketches of that theater in Colorado and details of his plan. CNN legal analyst Phiip Holloway joins us now. Philip, there's a lot of discussion about what psychiatrists can and can't do before a crime is perhaps committed. I'm curious if that's in any way relevant to what this jury is hearing, because this jury is not deciding that. This jury is listening to this testimony and trying to decide whether James Holmes is sane or not.
That's exactly correct. This is a medical legal determination that they have to decide. The burden is on the state to prove that he was sane. All he has to do as the defendant is to raise the issue. They have to prove beyond a reasonable doubt that he was in fact sane. And from this witness yesterday, I think they got some very good information that just may help them carry that burden. For example, she testified that he hid from her his specific plans. Why would someone hide their plans? It suggests that they knew that what they were doing was wrong, and that, of course, is the legal test for insanity, is whether or not he knew right from wrong, or whether or not he was unable, based on his psychiatric condition, to form any kind of criminal intent. So I think that her testimony yesterday definitely helped the prosecution. Insanity defenses are rarely used, and when they are used, they rarely succeed. So I think the advantage has to be with the state at this point.
Oh, and it's interesting because Colorado is one of the unique states where the burden of proof in this situation is on the prosecution to prove that he was sane rather than on the defense to prove that he was insane at the time of the crime. During her testimony, she talked about kind of the progression of his illness, or what she saw, that he obviously had homicidal thoughts, and that she diagnosed him with social anxiety, with obsessive compulsive disorder. She said then later it evolved, she thinks, into further problems of paranoia and psychosis. When you're kind of reading through all of that, it does lead you to believe that the defense has a lot to work with here, though, yeah?
Well, that's true. She did give something to both sides. She gave something to the prosecution, and she gave something to the defense. Really, all they have to work with is the insanity defense. And before they can get to the question of whether or not he was legally insane, they have to establish that he had some type of mental disorder, a mental disease, defect of mind, however you want to characterize it. So to that extent, she did give some valuable information on cross-examination to the defense counsel. However, on balance, the key pieces of this, the nuggets, if you will, that when the closing arguments come around, I guarantee you the state is going to be pointing to the fact that James Holmes hid from his treating doctor the fact that he had specific plans. Why would you hide something unless you knew that what you were about to do was wrong?
Hey, Philip, though, there are questions in the greater society now about what a psychiatrist should and shouldn't disclose prior to a possible crime that is committed. In your experience as a prosecutor, do you think the jury sits there and goes, well, wait a second, you know, this psychiatrist who we're listening to testify in the stand, this person could have stopped this killer. This person should have stopped this killer. In any way, does that impact their ultimate decision on guilt or innocence?
Only time will tell, because you never can tell what a jury is likely to do or what's going through their mind at any point in the trial. The reason that doctors in general, and specifically psychiatrists, are not able to disclose things that are told to them by their patients, it's just like the attorney-client privilege. It's actually on par with that. Because when people have psychiatric disorders, especially ones that are as severe as what he clearly had, you want that person to seek treatment. And so they will be unwilling perhaps to seek treatment if they believe that their doctor can go and reveal anything that's been told. So as a matter of public policy, the law builds in this patient-doctor confidentiality that will apply, and only if the doctor has some specific actionable knowledge that she can call the police and say, hey, I've got this client that I believe is about to go do something imminently and that it's going to really hurt somebody or they're going to kill somebody. Only under those circumstances can they ethically disclose any communications that are made.
Phiip Holloway, thanks so much for being with us. Appreciate it.
Thank you very much.
Thanks so much.
All right, there was a